And now it's
All
for
right,
real.
well,
Yeah.
thank you everyone for showing up, and thanks Sean for coming and speaking to us. I'm very excited and to have Sean Stigler here with us. He's not just a great venture lawyer and startup lawyer, but he's also an entrepreneur himself. He's managing partner at Michael Best and Friedrich LLP, and a managing partner at Venture Best, which specializes in helping startup founders set up correctly. So great to have you here. Thanks for making the time. And I know that you have a close relationship with our partner Felipe, so I'll let Felipe give a couple of words if he may.
Oh.
You're on mute.
Perdón. ¿Qué tal, Fernando? Estaba despistado, perdón.
Felipe, just we were asking for you to give a little bit of context of your relationship and how you got to meet Sean. And
Sorry about that. Basically, Sean and I met through Venture Best. Well, it wasn't Venture Best, it was Michael Best. And basically we had the opportunity to meet together via Zoom. We haven't met yet personally, because I was working with Michael Best, which is one of the, it's the firm that oversees Venture Best, and that a long time ago, Sean, I believe, sold to them. So that's how we got to meet. I explained to him how we work in One Trip and the philosophy, and basically that's how we began to meet. And then I introduced him to Carmen, and then to Fernando, and that's how we got here into this mess in the middle of a soccer game today. I'm sorry about that, Sean. We all missed that one. Sorry about that.
No worries. Well, even though I'm American, or from the United States, I grew up playing soccer. I played soccer in Europe for a while. I love soccer. So for those who are here, thank you. And maybe I can just talk really quick, and then everyone can get to the game. But no, appreciate the intro. And yeah, just to set the stage, I am an attorney. I'm also an accountant. I love startups. So I spend about half my time, and our team does the same. There's about 50 of us around the United States, here, Austin, North Carolina, Chicago, DC, bunch of other places, but we spend about half our time with companies, everything from what we call two kids in a garage. So those companies at the very, very beginning of their life, and hopefully help them get set up on the right path and not step on any landmines. But then also we work with a lot of family offices, venture capital funds, private equity funds, a lot of what we call corporate innovation funds. So funds that companies set up to invest in innovative companies. So, my only priority here is to be of service to you all. I promise I won't try and sell anything or make lawyers seem smart, but if I can be helpful, and whether it's during this call or after, if you have questions, it's what gets me out of bed in the morning, is helping folks like you all. So, yeah, I guess Carmen, should I kick into it?
yeah.
All right.
And I guess Greg is gonna be the lucky one to have the most questions and availability from Sean. So
the beauty of being Italian in Latin America.
Exactly.
Not a big fan of Latin American football.
Yeah, I was gonna say if the United States was playing, I might not be here. So I'm just trying to get this to my other screen. Pardon me 1 second, I'm just gonna move this over. Otherwise you're gonna look at the side of my face this whole time, and that would be not fun. So sorry for the lag here. I didn't realize I wouldn't be able to move it over. Oh my gosh. All right, you might just have to look at the side of my face. All right.
Don't worry.
We're a Teams firm, so I'm not as adept in Zoom as I am. So can everyone see my screen now? Awesome.
Yeah.
That's great. All right, so I thought what I would just touch on for everyone is just a lot of times when you have a startup company, first of all, unfortunately, we make the laws and the taxes more complicated than they should be. And so I want to just give like a little bit of a foundation of things to avoid, things to be thoughtful of, things to think about with your co-founders. And then the other thing that comes up a lot when you're a founder, which I've also been and invested in a lot of angel companies, or as an angel in a lot of companies, you get this, what we call like cocktail party advice or half-cocked advice. And so I just wanted to touch on some of those. And again, anytime during this, if you want me to double click on something or go deeper, just let me know. So, so with that, all right. Yeah, so a couple things I want to touch on, just sort of 101 startup things, some capital raising and securities laws issues, employment and intellectual property, 83B elections, and then trademark, and then just some other mistakes that we see a lot of people make. So, and then Venture Best, Felipe and Fernando did a great job talking about us already. The one thing I would add to that is we do love, because we sit at this intersection of capital allocators, is kind of what the cool kids call investors now. So anyone who's putting money in motion, trying to make an investment, and innovators, you know, one of the things we do a lot of is help make introductions, help find synergies, you know, really buttress what Fernando and Felipe are doing, but as you may continue to grow or need more. So always happy to be a sounding board there and tell you what's market, what's not. So, so all right. So a couple just initial things, and I think, Carmen, help me understand, like everyone who works with you has already been, you and the team has already been set up as a Delaware C Corp or no?
Yeah. Whenever we invest, they don't have to have a Delaware LLC or C Corp or Cayman entity structured, but we do guide them before we do the investment. So or guide them in the right direction of lawyers or providers.
Okay. And I'll just add that in general, our companies use the LATAM sandwich or the Cayman sandwich, where they start off with an LLC, as long as they're racing with safes, establish that, and then they either go to Cayman or Delaware C Corps, depending on you know, if they're going to touch the U.S. later on, as from a revenue perspective.
Okay. Thanks, Fernando, and thanks, Carmen. Yeah. And I'm actually a big fan of LLCs. A lot of venture lawyers are not, but I think they have a great place, especially if you're an intellectual property intensive company. It can preserve a lot of options, especially on the international tax front. So, so given that, it sounds like you guys have a pretty clear path there. And I know Ecuador doesn't always love Delaware domiciled companies when you're dealing with that. So I would say on that front, you know, if we can ever be a resource, if you have questions about if it makes sense to have a United States entity, you know, there's Delaware, there's Wyoming, there's Nevada, there's a variety of states that are actually really good. Obviously, institutional investors are most used to, US institutional investors are most used to Delaware, but there are other tools, and we see that. One thing, Fernando, and Carmen, if some of your companies are starting off as LLCs, which again, I'm actually a fan of in a lot of situations, there is something, so we'll talk a little bit about QSBS and 1202 in a second, but for those investors or founders depending on how they structure it, who qualify for that, there's a really cool step up you can do if you start as an LLC. So, and you may be familiar with this, Fernando, but if you have companies that are LLCs and are going to convert to a C Corp, there's a pretty cool trick you can do to really supercharge the tax savings of QSBS stock. So that's another thing we always like to get in front of folks if they're going to do that. And for those who don't know, Section 1202 of the US tax code, again, for those who qualify on the other levels, allows investors to exclude a significant amount of capital gain from tax. And it's either the lesser of 10 million or a basis amount. And so by converting, you actually get this supercharged savings. You can take it up to like $100 million plus if you do it right. So just something to flag while we're talking. So going quickly here, the other, talked about a couple little nuances, but as you're starting a company, regardless of the formation, I think the key things for the founders to think about is who owns what, who's doing what, who gets paid what, who's contributing what, who controls what, and who will be involved in the future. And whether you're doing an LLC or a C Corp, those are really the things, and I'm sure Fernando and Carmen and the team help flush this out and coach you on this. But unfortunately, as you've probably heard, the statistics for businesses surviving are not always the best. And sometimes, like we're having right now, there are some economic headwinds to the high growth market. But there's also, frankly, a lot of opportunity. Like if you look at the 01, 02 class of companies that came out after the original tech bubble crash, and then the 08, 09 companies, it was two of the most explosive, successful times for growth companies. So as we're going through a stressor in the economy, it can actually be a great time because there is a lot of talent. There is a lot of, not everyone has a $300,000 a year job at Facebook like they did the last couple of years. So you can actually hire talent. And that actually makes these points all the more relevant is, just making sure everyone's on the same page, who owns what. So are some of the founders going to contribute capital or other property? Are some people bringing other things to the table? How are we going to break that up? And then the other thing that often is a death knell to companies is not really delineating or being clear about who's responsible for what. And again, this isn't so much even a legal issue, but just making sure you and the other co-founders spend time together figuring out, hey, who's going to do the books? Who's going to do the SEO? Who's going to do, the branding? Who's going to own these things? And going through that process, one of the things it does really well is points out if there's holes in your founder team or holes in your resources where you need to reach out to, the team here and find resources to fill your shortcomings. The who gets paid what is obviously an important thing. So with your investors, whether it's safes or as you start to get into priced rounds, the preferences and things like that, being thoughtful of that. We're seeing, unfortunately, a lot of that in the market now where you hear the pref stack is kind of a common venture term. So a lot of companies, unfortunately, are having down rounds right now, and the preferences are going to eat up all the value of the company, for lack of a better term. And so being really intentional when you set up a company and you start taking on investors as to what that's going to look like is really key. So, all right. So yeah, the next topic I just wanted to touch on is fundraising. So again, you're getting great advice. You're using the preferred tools with this team. Our advice to founders is always make your product and your service and your offering as unique as possible. make your accounting and legal as boring as possible. So, using tools like safes and simple, sort of market documents is what you want to do. That being said, especially with international interactions, we do want to be mindful, be thoughtful. And again, if it's me or any of my team or my tax colleagues, we're always happy to chat off the clock. If you have, different countries have different treaties, different interactions with each other. So like Fernando, like you mentioned, the sandwich, and there's also like a Dutch sandwich, depending on certain treaties. A lot of our clients will use a blocker company, corporation, depending on where the money's going to flow. So unfortunately, the tax treaties are pretty complicated, but those of us who do it 1,000 times a year can cut through it pretty quickly. So reach out to us. The other thing, so like I said, keep it as simple as possible. I don't know if folks are familiar with 409A valuations. Greg, give me a thumbs up or thumbs down. Thumbs down, okay. So for US companies, which obviously is my bias or the hub of my knowledge, a 409A valuation is a value that the Internal Revenue Service, it's a code section that talks about the value of a company for a variety of purposes. And one of the ways they get to a 409A valuation is if you sell equity at a certain price, that creates a 409A valuation. So I have a slide here in a sec, if you sell 1% of your company for $1 million, the 409A valuation of your company is now $100 million. And sometimes what people do when they're first starting up is they'll do a friends and family round, or someone will do, you have the rich uncle who says, hey, I'll give you $1 million for 1%. I don't need the money. I'm just trying to help out, or something, crazy like that. But the unfortunate thing of doing that is now you valued your company at $100 million in the eyes of the IRS. And so if you give a developer or an advisor any equity, you've now created a massive tax consequence for them. So again, just be really thoughtful as you're taking money. And it's, again, one of those things, talk to the team here, feel free to reach out to me. An ounce of prevention goes further than 10 pounds of cure with these issues. It can be really hard to undo things. So the other thing, and I don't know if Carmen and Fernando, if you have like a reading list, but Venture Deals is my friend Jason and Brad wrote that, and I think it's one of the very best books.
Top of the list.
Okay, yeah, it's so good. Okay, great. So yeah, I highly, highly recommend that book. It's a pretty good listen too, for those of us who fly a lot. It's good to listen. So I'm going to skip that, so we keep going. So the next macro topic I just want to talk about is employment and intellectual property. So Carmen, for the team, are some people still have day jobs or other things they're doing, or is everyone in your platform full-time?
Everyone's full-time founder.
Okay, great. So for you all, then this first question or this first issue isn't directly an issue for you, but if you hire other folks or you work with other folks that, especially in the United States, if they have another job and they're working for you on the side or they're co-working, a lot of US companies have clauses in their employment agreements that says everything developed while someone's an employee of Google, IBM, Apple, whatever, is the property of Google, Apple, whatever. And so again, it sounds like you all don't have this issue directly because you're full-time founders, but just be really mindful of independent contractors, employees, anyone you're working with. If they have another job, you're putting the intellectual property they're developing at risk. So there's ways we can flush that out, make sure it's not an issue. The second thing is anyone who works for you, you want to have them sign what we call a PIPA. But what that is just and this law is actually changing for US citizens in a lot of states. So you have to be careful, but you want them to sign what's called a works for hire agreement. So everything that they do for you, everything you compensate them for, whether it's with cash or equity, is the property of the company. And they're assigning all that to you as a matter of law. It's a simple document, but it's really important. Those of us who've been around a long time can tell you horror stories of companies about to file an IPO, companies about to do a big raise, and the developer says, hey man, I own this still. It's not the company's property, or this is still my intellectual property. And I mean, the most famous one, which many people on here are too young to remember, but there was a company called Yahoo, and the advertising campaign, the person who's the star of that didn't sign one of these, and there was a huge lawsuit right at the IPO, and it delayed the IPO like 2 weeks. So it does happen. And then the third thing about intellectual property, again, focusing on the United States, we have a very interesting system. So for anything that's patentable, which, you know, there's mixed thoughts about whether patents have value, but for certain companies they do, you cannot share anything that's patentable, especially internationally. So like at trade shows, conferences, anything like that. If you put something that's patentable into the public domain, you can lose the right to patent it because you have put it in the public domain. So if there's something you think could be patentable, and that can be business processes, you know, algorithms sometimes are copyrighted, sometimes are patented, sometimes are trade secrets. But if you think it can be patentable, talk to someone who knows and at least explore that. Conversely, and we'll talk about trademarks here in a sec, your brand, your trademark, all that kind of stuff, you can put out in the public domain and do the trademark later. It's just patents. So so this one, just a quick slide. And truthfully, I don't know how this is affecting in all the countries, but in the United States, there's been a big push back against non-competes. So a lot of people say, hey, non-competes aren't enforceable anymore. Colorado, where I am, they just passed a law really restricting non-competes much more than they were a year ago. And so a lot of people are like, well, you know, I'm not even going to try and do a non-compete. And it's more nuanced than that. So almost every state in the United States, and especially Delaware, will still protect any sort of trade secrets, client lists, customer lists, know-how, anything like that, and can also restrict you from taking any information that you learned while working at a company, starting a competitor, working for a competitor, things like that. So if you're sharing really key information, or you have key founders or co-founders, there is still a place for non-competes, non-solicitations, trade secret agreements. Don't just throw all those out the window, because there is still a lot of protection that you can easily build for yourself there. All right.
Can I ask a question regarding that?
Of course. Yeah,
It wasn't as clear for me. So it's changing and it's less enforceable now. But where do you draw the line?
Yeah, absolutely.
What kind of employees are worth the fight?
Yeah, no, it's a great question, Carmen. So in general, so there used to be non-competes that were enforceable that would say, hey, Carmen cannot work for any sort of accelerator or venture capital company in the United States for 3 years once you took this job. And that could actually be enforceable. Anyone in a leadership role, you could just keep them from working with any competitor. Those in most states are getting really restricted, are really getting cut back on. There still can be enforceable if you sell a company. Those are even that broad of a non-compete is still enforceable. But what's almost unilaterally enforceable is any employee. So it doesn't even have to be a high-ranking employee. They cannot take any pricing, client information, secrets, future branding, future products. They cannot take that from any company and use it against the company, or we call it circumvention. It's called a non-circumvention clause. It's kind of a fancy phrase. So all of that is still very enforceable. Not so much for independent contractors, but for employees. And then for high-level employees, so, you know, a CTO, a director of marketing, a CFO, anyone like that, you can even have higher level restrictions still. So is that helpful, Carmen?
Yeah, thanks.
Okay, yeah. I know 83B is really just for US citizens generally. Is that something you guys touch on? I can kind of skip that.
Fernando, is this the what Jorge brought up in the group a couple of months ago? Or am I mistaken?
I can touch
Not-
on it too.
Not
Yeah.
sure. I've had to
Okay.
deal with it for sure.
Okay, yeah. And I was going to say, you'll have people who are US citizens that you interact with. So basically, I'll just give the 30,000 foot view of 83B elections. This is a really, really big issue if you're a US citizen. So Greg, if I work for your company and I'm a US citizen, and you say, hey, I'm going to give you 3% equity in my company that vests over a couple of years in exchange for services, I have two choices as a US citizen. I can make an 83B election and file taxes on the value of that 3% now. And the cool thing about this is, no offense to all the founders on the call, but your company's not worth that much at the beginning. So if I get 3% of a company that doesn't really have a lot of money, doesn't have a lot of customers, I can maybe argue that, oh, that 3% is worth $5,000 or $10,000, like a small amount. And as long as I make that 83B election, even if that 3%, you know, Greg, your company turns into the next Google, and that 3% is worth $3 billion, everything in between there, I pay capital gains tax on. So that's the best outcome we can have in the United States. If I don't make the 83B election, I don't have to pay taxes when I get the 3%. But as it grows, I pay ordinary income tax on that whole value, which instead of being 20% is 40% or more. And like California is about to go to 17% state income tax too on ordinary income. So you could be talking 57, 60% tax if you don't make that election. So for anyone has US citizenship or is otherwise subject, like a green card in US, this is just something where if you're issuing equity, make sure you're thinking about this. All right, home stretch. So trademark, this is a really big one for everyone who touches the US market. And there's also, you know, international treaties for trademark around the world. So one of the other horror stories we see with a lot of early stage founders, I could tell you many, many examples, is they come up with a name, they search Google, they go on, you know, GoDaddy or whatever. Oh yeah, the domain name's available. So this name is good. I can start using it. And the fact that you can find a name, the domain name, or the fact that you do a quick Google search and you don't see anyone competing is not the end of the story. So what we recommend companies do is something called a knockout search. And you can do it with us. I'm sure there's other companies that do it. We pay a service to do it. And they search what's called the USPTO, which is the US Patent and Trademark Office. They also search the EU. They search a whole bunch of the other patent and trademark offices around the world. And what they will do is say, so I'll give you an example. We had a client that set this up before they came to us. It was called Soul Bites, like SOL Bites. And it was really cool little healthy snacks for like camping or going to a soccer game and like tailgating. You wanted to have these snacks. And so they had searched Google, they bought the domain name, and then they started to really get great traction. And they got picked up in Walmart and REI, which is a big like outdoor store here. And they had created hundreds of thousands of dollars of inventory. And then Frito-Lay, which is, if you don't know, like a huge, Frito-Lay sent them a letter and said, well, what the hell are you doing? We own this name. We're just not using it right now, but we own it. And so this company had to destroy all their branding, all their marketing. They had to shut it all down because Frito-Lay owned it and wouldn't let them use it. And so, a knockout search, it isn't even really a lawyer-driven process. It's $1,000, $1,500 tops. So that's something I just highly recommend if you, if your brand is important to the company, the name of the company, the public face is important, do that early before you invest a ton of money. And then the other thing is, again, trademarks for a lot of growth companies, it can be one of the most valuable assets. And so just a little bit of proactive strategy on that. And if you talk to anyone, we have a big trademark team, they can also help you with what'll be protectable, what's not. So the way it works is like descriptive words are not protectable as brands. So that's why, Google, Apple, all these companies, NVIDIA, they're whimsical or infertive names that, you can't have like Black Computer Company to describe your computer company that only sells Black computers or something. You can't protect that. So if you ever want to strategize or that becomes an issue, we have an awesome trademark team that would happily, consult with you off the clock and advise on this. Emily Haas, if you ever wanted, Carmen, she gives much better presentations than me in general, but especially about branding and that strategy. She's awesome. So
we'll take you up on that.
Okay, yeah, she's fantastic. She gives talks all the time. So again, the fact that you Google the name or check to Secretary of State or Division of Corporations, that does not mean you can use that name. It just means no one's picked that exact name. So a couple other things, having been a founder and worked with a couple thousand companies. So especially in the United States, the government rather holds you all personally liable for any liabilities of a company. It is a present, it is a gift in the eyes of the government to create that corporate shield between the company's liabilities and you personally. So one of the main things we see when people are creating a company is they don't put the world on notice that they're dealing with a company, either a corporation or a LLC. So they might just have their brand, like, for example, like you'll see sometimes, I'm just trying to find one right here. Well, you'll see things on a website or whatever where it's just the brand. And then when it's done right, you'll always see at the bottom, like, Michael Brest and Friedrich LLP or copyright, blah, blah, blah with the company name. So whenever humanly possible, let them know by having the INC for a corporation or LLC or LTD for a LLC, that it's a LLC. And then any of your contracts, anything you sign, even if it's just with a, AWS or something like that, put the full company name every time. That's so important because even if you miss it sometimes, it can have terrible consequences. The second just hygiene thing we always really stress, especially having been an accountant, is keep your personal money and your company money separate. It's really easy to mix the two. And it is the first thing that gets brought up if there's a lawsuit against a company is, oh yeah, Carmen paid for her soccer tickets out of the company account. Well, since she did that, her personal assets are fair game for any sort of lawsuit as well. So you really want to create a company bank account and keep it separate. I also am a huge fan of using American Express or Capital One card, get a business card for your company right away. You'll have to personally sign, like it'll have to be your tax ID number because the company won't have credit. But that way, when you get to the end of the year and you're doing taxes and you're trying to keep track of what you spent on different things, you have that credit card, saves you so much time and money. That's fantastic. Especially with international companies that have to deal with multiple jurisdictions. Make sure you're filing the annual reports, tax returns, all that stuff. Once you get delinquent on that, it's such an expensive pain to dig out of that hole. And then the last thing is just always make sure you're signing what I always tell people is whoever signs a contract or an agreement is who gets sued. So if I sign an agreement, Sean Stigler, and that's it, if something goes wrong, they sue me. If I sign an agreement, Michael Best by Sean Stigler, then I'm signing on behalf of my firm, not me, and they sue the firm, not me, which is what we want. So those are just a couple little best practices. And I went really quick. So in case the game is amazingly exciting, and or there's questions, yeah, we can go to that. So
I'll start. I had an anecdote that happened to me when I moved to New York, and we started a joint venture with my partner. And so we decided to call it Financial Technology and Design Group, FTD Group. And the first version, we built the website, launched it. Like a few weeks later, we get a cease and desist notice from a lawyer that represented FTD, the flower arrangement florist thing. And it was like dealing with a hound. I mean, he would not let go. He bit onto us and would not let go. And even though it was very hard to nobody would ever think, oh, financial technology, yes, florists. But anyways, we had to finally tweak the domain and change the name. So we dropped the group and basically we just became FTDG. With a dash in the middle.
Yeah.
And
it's really tough. And the way the US law works is if you have a trademark, you have to enforce it or you lose it. So it's not even just that this guy or woman was a jerk and overly aggressive, but the company has to enforce the mark. Otherwise they lose it. So it makes people be really aggressive. Yeah.
Right. But the point is, it doesn't have to be exactly the same. It can be similar. And so he was saying it can be confused. And that was enough for him to not let go.
Yeah. And almost always, I mean, we do this so often. You came up with a great one, Fernando. You can usually just tweak it a little bit or add one more word or do something and that'll be okay. And sometimes too, if you have a name that might be similar, you can reach out proactively and say, hey, Google, we're thinking about starting a company called Gaggle, and it's a farming technology company. So it has nothing to do with Google. It's pretty different. We just want to make sure we're good, and what they can do is write you a license agreement or a no action agreement that says, hey, as long as you stay in this space and you're not doing web search and your name is actually Gaggle, not Google, we're good, you know, and that way you can spend the money on the branding and all that stuff, knowing you're not gonna get sued a month later. So.
Alex?
Hi, yes, thank you. So one quick question on the knockout searches. You mentioned that your services cover the US and perhaps some other areas like the EU. A lot of our founders have operations across LATAM. Does your firm or similar firms also cover databases in, you know, all of LATAM, or how would you approach that problem if not?
Yeah, no, great question, Alex. I know we can search on LATAM, and Emily Haas, I just don't know the exact price on that, but it's almost always really reasonable. And what that knockout search does is it'll give a list of everything, kind of like Fernando said, that's close. And then the way trademarks work is they have company codes. So there's a code for like computer manufacturing, there's a code for grocery store, there's a code for shoe company. And so even if there's generally, like, say your company's Twitter, but you make shoes, like, you might be okay. If you're Twitter and you wanted to have your name be Twitter, and I know they just changed their name to X, but if you wanted to be Twitter and you were like a technology company, we'd say, don't do that name. Like, there's no chance you're going to get by. They're going to sue you. So, but I can find out for you guys what it would cost. Because again, it's not even something like we don't profit from that. We just pass through the cost of the services. I can find out like how they do the different buckets.
Turning a little bit to the valuations, company valuations and taxes. As far as I understand, the 83B election does not come into play if you're dealing with options, or because the option is not considered a direct equity yet, right?
Yep. And so the 83B is for what we call restricted stock or restricted units in a LLC. So that's where the 83B, and that's a lot of times like, and you know this, Fernando, like if you bring in a good board of advisor member, or sometimes like we just had a company get a very high profile CTO, and we said, okay, the CTO is going to get 10% equity in the company. Who's a very high profile CTO, over the next 4 years, filed an 83B. Stock options, because they may never have any, they might not be in the money, or they could be taken back. There's no 83B for that. There is like what's called incentive stock options. We call them ISOs. And then the other phrase is non-qualified options. So there is some tax planning for options, which my partner, Carrie Burns, that's all she does all day, every day. She's awesome too. So if you ever wanted to do like an hour-long session on options, or she also does a lot of like what we call phantom equity, especially for international folks. Sometimes that's a better tool depending on the treaty with the different countries. So she has great presentations on that if you want to go deep there.
Okay, and then for founder equity, that doesn't come into play because you're sort of putting even sweat equity in exchange, or does it always have to be cash?
Yeah, it's a great question. So generally, and this is nuanced, but because I don't know if you guys have standardized corporate forms that you kind of push people to, but if you do, if you put the right phrases in there, they will have a what's called a subscription or a contribution in exchange for their equity, and that will qualify the founder for long-term capital gain. If not, one of the things we often do is what's called a preemptive or prophylactic, just like a protective 83B election for founders. it doesn't hurt anything. You know, when you start a company and there's nothing in it, you can say, hey, I own half and Carmen owns half, and right now it's nothing. And so we're making an 83B election and the value of our shares is $10. So, you know, you pay $1 a tax or something like that. So sometimes we'll do that just to be doubly safe. But if you have the right wording in your company documents, you should be fine too.
Mhm. Then the last question on that.
Yeah.
If you've only raised through safes so far,
Yep.
Is that considered like a 406
409A?
409A valuation, or do you go and like do a separate valuation with like a valuating company?
Yeah, that's a great question too.
Valuation company?
So one of the reasons I'm older than everyone on this call, so we used to use convertible notes, and now we use safes. But one of the many reasons we love those tools is exactly to your point, Fernando, is it does not create a 409A valuation, because the whole idea of a safe is we don't really know what the company's worth. So we're saying, hey, in the future, when an institutional investor comes in, we get to convert at a 10% discount or whatever. So the question people always ask after I say that is, yeah, but the safe has a $5 million valuation cap or a $10 million valuation cap. So doesn't that create a value? And the answer is so far, no. There's been some cases over it in the United States, but everything is held because we don't know whether the discount or the valuation cap is going to trigger. Sometimes they get negotiated by institutional VCs. So it's still just a contract for the right of future equity, hence the name. So far it has not created a valuation. It's interesting because we're seeing in the market right now, which you guys know, a bunch of companies raised on safes, then did priced rounds the last couple of years, and now the later stage venture capital market has dried up, and so they're doing safes again as like a bridge round, and so it'll be interesting. There could be some challenges there, but knock on wood, so far that's been fine. Yeah, great questions. And I wish I spoke Spanish better. I can see the chat, but I can't read it all. Yeah.
Alex and then Rodrigo.
Sure, just one other question, thinking about the liability. Again, our founders have operations in many countries, and they could be at a stage where they are testing out a market, and then they may or may not stay, or just as they continue to grow, consolidate their legal presence in new markets. So do you have any advice on how to mitigate risk? You talked about always, signing with the company name and always being the company, but I assume that the protections you can't say, oh, I'm a company in the US, so I have US protection if you're not constituted in another market. So do you have any thoughts on that? How they might approach those challenges?
Yeah, absolutely. So to be a lawyer, which I am, I would always say just like reach out to me or someone like me, and we can coach a little bit, because some countries you can register. So I understand they're just trying out a market. They might not, spend a lot of time there. But some countries you can register as a foreign corporation, and that gives you a lot more protections. And sometimes it only costs $20. And you just say, hey, I'm a US Delaware corporation. I'm doing business in Canada. I'm just like letting Canada know I'm doing business here. And sometimes it's very cheap, very easy. You can do it online, and that'll give you a lot of protections in different countries. The other thing which I didn't go into, which is a whole nother talk, is if you have data privacy, data usage, data sales, that's one to be really careful with, because all the countries and all the states in the United States are coming up with new data privacy and security laws. We have like 7 people right outside my door here that's all they do all day, every day. And that's one to be really careful with. Obviously, you probably have heard of GDPR, which was kind of the first one, but California now has one that's even worse. And the tough thing is if you have like an app company or, you know, a SaaS company, you might not know that someone in California is using your software. So that can be really difficult. So again, always happy to talk without charging you, give you some strategies on that. Same thing with different countries. If you tell me the countries that they're looking at, either I or someone on my team can say, you know, register here, don't register there. Here's a good one. The other thing I would say is if this company rents an office, has employees, hires people in a country, that elevates your, we call it nexus, your connection with that country. And then almost always you want to register with that country. Otherwise you can definitely have exposure there. So Carmen, I can send, and Alex, I'll send, I have kind of like a liability protection summary. I can send that after to everyone that goes into more detail on some liability protection stuff. And some of it depends too, Alex, like I don't know what your company is. I always, but.
Buen Trip.
Oh, you're
It's part of the
I'm
Buen
part
Trip.
of the team, yeah, but
Oh, okay, sorry.
interesting thoughts anyway.
Yeah. I always joke, like if you're like an arms dealer or a, you know, fireworks manufacturer, then you have to be a lot more careful than if you're selling shoes or something like that. So if it's service-based like you guys and you're, you know, just advising, strategy, consulting, it's not as big a risk. Yeah.
Rodrigo, are you there?
Yes, I am. Wait a second. Can you see me?
Yeah.
Yeah.
Hey, Sean.
Rodrigo.
That was really insightful. Thanks for the answers. I have one question. I think going back to the early part of the conversation when you talk about the founders, I understand the checklist that you need to talk about when you're with a co-founder, but what about when things go south? What are the checklists that you need to cover when the relation is over?
Yep. No, it's a great question. Frankly, LLCs, there's a lot of what I would call like dials and levers you can build into your operating agreement. So that, you know, when I talked about, Rodrigo, like the making sure you know who's doing what, who's responsible for what, who's contributing what. So say you and I are partners and it's not going well because you were supposed to have the first software launch by July and you didn't do it. Well, if we had sort of documented that that was your responsibility, then we can have consequences that say, hey, Rodrigo, you were supposed to do A, B, and C, and you didn't. So now, you know, I have the right to buy your shares at a discount, or you don't get paid, or, you know, we can put all sorts of penalties in the document for not doing that. You know, truthfully, a lot of founders, the companies always change through time. And very often if 2 or 3 people start a company, 5 years later, it's not the same 2 or 3 people driving it. More often than not, people, you know, what ends up happening is maybe that original founder will keep a tiny little bit of the company, but then the rest of it will go back to the founders who are still there every day, all day, busting their hump, trying to grow this company. That's what we see 9 times out of 10. Every once in a while, someone is just a total pain, won't give up their equity, you know, wants to fight. And there's things we can do there. But the more you can be specific when you start a company as to who's responsible for what, you know, who's doing what, and then you can put consequences in there. The other thing you can say is like, hey, if you get this would never happen to you, Rodrigo, but hey, man, you were stealing money from the company or doing bad things. Like that's an easy one. It's just like, hey, man, if you're convicted of a felony or you do something to tank the company, we have the right to buy your shares for a penny. That one's real easy. But some of the other ones, they do tend to be gray. People can fight about it. You know, the other thing you can do is you can put in teeth, like if you guys are putting in some of your own money or agreeing to work full time on the company, and then one of your founders flakes and gets another job or moves away and isn't contributing, you can say, hey man, you're not living up to your obligations. We get to buy your shares back at, you know, a fraction of the value. Is that helpful?
Yes, but just to make double click on something, right?
Yeah.
Let's say now that the relationship is finished, how's a way that you can protect yourself, like termination agreements or somehow what type of documents should you sign?
Yeah. Oh, sorry. 100%. And if you ever need that, we have those standard, because as someone who represents a lot of investors, I can't tell you how often you and two guys start a company and then one of the guys is gone and you're like, oh yeah, he's cool. He knows he's not an owner anymore. We just never papered that. The investor's like, no. That needs to be documented. I need to have that signed. So yeah, we have a termination agreement. The company will repurchase the shares, and we'll have him sign something that he forfeits or she forfeits all her rights of, you know, any future income or ownership of the company. We definitely have that pretty standard.
Great. I think that's on my end. Thank you.
Okay. Hopefully you don't have to deal with that. So, yeah.
Yeah, what can we do?
Yeah.
I think we have time for one more question.
Oh yeah, sure.
Carlos.
Thank you, Sean, for the
Yeah.
insights. I just want to double down on something that Alex mentioned earlier, and it's like the fact that we work with like country-based relationships. And for instance, let's say in our case, we have like a Colombian-based company now, which is owned by the LLC holding.
Yep.
And my question is regarding like the IP and the employees. How would you recommend like managing local employees, let's say in Colombia, that are part of the, like in the bigger picture, part of the LLC holding, like because that LLC is the owner of the local entity. How would you recommend to manage that in terms of like they are executing code, they're executing specific things related to the IP? Would you recommend like to go in like just to have the local regulations, or maybe have like double agreements? What's the take there?
Yeah, no, that's a great question. And we actually work with a fair amount of Colombian-based companies. We're actually doing a really cool company out of Australia right now too. And it's, again, just to be a lawyer, the answer is it depends. So I would say when you're a young company and you have just a few employees, and you're not trying to raise money outside of Colombia, or other local countries, I would say keep it simple, stupid, and keep it in Colombia and pay lawyers as little as possible, but do it right, have the right agreements and all that. As you grow, you know, as I'm sure others have told you, most US investors will only invest in US companies. And so a lot of times either we have to move the intellectual property to the United States, we might have to have agreements with a US based company that's going to hire the Colombian company to do service and things like that. So as the company grows, and this could also be for, you know, Ecuador or other countries where you're doing a lot of work, you might need to create another entity. But initially, as long as you, and truthfully, I'm not an expert on Colombian law. I could get one of our colleagues connected on that. But in general, I would say do it right in Colombia, paper it right in Colombia. And then if you really start to grow, then we can look at other, what we call domiciles or places to organize the business. But yeah, I know that's not an awesome answer, but it's kind of a tough one for me because A, I'm not a Colombian expert, and B, most of the companies I deal with, they've gotten to a size where maybe they have 50 or 100 employees, or they're trying to raise, $10 million or something. And it's like, then many of them have to come to the United States to get the investors they want. And then that part I know how to navigate well, but yeah.
Fantastic. Thank you, Sean, for every answer and for the talk itself.
Of course.
We're definitely gonna take you up on offers of documents or specifics that you've discussed today, and yeah, we're gonna reach back to you whenever there's the case of those startups in the portfolio that are looking to scale in the US especially.
Okay. Well, no, thanks for the opportunity. And I know I am, just since we're missing the soccer game, I am like the midfielder of our team. So we have, great goalkeepers, great forwards. I'm kind of the generalist. So to the extent I couldn't answer some of the questions, whether it's employment, tax, trademark, we have the team. I'm always happy to connect them with you all and help advise more specifically.
Fantastic. Thank you so much, Sean.
Yeah, good to meet everybody. Yeah, good to see you, and congrats on the pending baby, Carmen. Yeah.
Thanks.
Thank you, Sean.
Of course. Thank you. See you.
Bye.
Bye.